before you has 3 allegations. Allegation number 1 relates to the Constitution. Allegation number 2 relates to alleged crimes of the national law, which unfortunately the evidence given is evidence that arises from personal cases about love and affection. And unfortunately, to the extent, unless that allegation is dropped, allegation number 2, we have to confront it. And if, as I will show you shortly, it is about love and affection and personal matters, then unfortunately we must confront it, even though it is sad that a committee like this would have its time being spent on such a matter. And number 3, we are here because it is alleged that the Honorable Linturi is guilty of gross misconduct. Honorable Chair and members, for you to uphold this motion, you must be satisfied on the material that will be presented by both sides that the Honorable Linturi has committed a gross violation of the Constitution, number 1. 2, that there are serious reasons, not frivolous reasons, not reasons tied to unrequited love and affection, that warrant a belief he has committed a serious crime under national law. And of course, you must be persuaded that there is an act or omission, a specific act or omission on the part of the Honorable Linturi that constitutes any of these 3 things, either a gross violation of the Constitution or a crime under national law or gross misconduct. We have, in our response, Honorable Chair and members, that we filed yesterday, presented before you a decision of the Supreme Court under annexure number 7 in our bundle, specifically on pages 132 and page 190 to be more precise, on what the apex land court in our land has said is the threshold that must be satisfied when you're seeking to remove a state officer from office for allegations such as the one before you. And when you read it, I will invite you to note that 1, there must be a specific act, a specific omission attributable to the Cabinet Secretary that is in question. I use the word specific, not nebulous and broad and vague and amorphous. Number 2, that act or omission which you must be satisfied has been committed, there must be a nexus between it and the Cabinet Secretary, which is to say, contrary to some of the submissions I've had, it is not a matter where you say some guy must be hanged for this, somebody must be crucified for this. No. The Supreme Court has said there must be a nexus, a link between the Cabinet Secretary and the matter in question. When you read that decision, I will invite you to note it also has certain evidential thresholds. It is very easy to allege things. Proving things is where things become a bit more serious. And the Supreme Court has set the standard in flyer number 7 of our battle. The linchpin of this case before you, Honorable Chair and members, is quote unquote that the Honorable Linturi approved the procurement and distribution of fake fertilizer. So for you to uphold this motion, you must be shown by way of evidence, not nice English, not high-sounding political speech, that the Honorable Linturi, quote unquote, approved. Cabinet secretaries make their approvals in writing. That's what our Constitution requires. We'll be interested to be shown the approval in question. Because without that approval, then the allegation must fall on its face. We will be urging you when we get there, Chair, to ask yourself whether, as a matter of law and fact, two things, law and fact, whether the Cabinet Secretary for Agriculture or indeed any other Cabinet Secretary is allowed, as a matter of law or fact, to approve procurement decisions, whether as a matter of fact the Honorable Linturi approved or in any other way engaged in any act or omission that can warrant the accusation that he approved the procurement of fake fertilizer. When we get there, Chair, we will urge you to read document number 3 in our Bible, and document number 10, and document number 21 in our Bible. And we'll be urging you to check and to find that when you read those documents, one, it is clear that the NCPB is a semi-autonomous government agency with its own board, with its own bureaucracy that is legally and factually immunized from ministerial control of the type that is alleged before you. We invite you to note, because the allegation is one of approving procurement of fake fertilizer, we'll be inviting you to know from document number 3 and document number 10 and document number 21 that there was no tender document for procurement of fake fertilizer. On the contrary, on the record before you, the procurement in question was quote unquote to procure fertilizer that meets the standards set by the Kenya Bureau of Standards. You will know from those documents that the accused person before you even took steps as per the document number 21 to remind that semi-autonomous government agency that they had to procure fertilizer that meets the specifications and standards set by the Kenya Bureau of Standards. Chair, this brings me to allegation number 2, which I said it is sad, we may want to wish days away. Allegation number 2 tells you that there are serious grounds for believing the Honorable Linturi has committed a crime under national law. What is the material that has been placed before you at pages 15 to 17 in support of that allegation? I mean page 15 to 17 of the motion before you. It is a list given there of court cases between the Honorable Linturi and the Honorable Member for Aldai constituency, which in the mover's own words, these are not my words, they are personal, civil, family, and commercial disputes. So it is not as Honorable Chair that I brought a matter of love, affection, and personal vendetta before you. It is ground 2 of the allegation on the record. All those 12, 15 or so cases cited there are personal disputes between the Honorable Linturi and the Honorable Member for Aldai constituency. And when we get there, the $1 million question is, if this is not a trivial matter of love gone sour, how did the mover of the motion use material of personal family disputes as the core basis upon which an entire allegation number 2 of his motion is based? But more importantly, when we get there, Honorable Chair, we have produced before you 9 decisions of various courts, ranging from the Court of Appeal, going to the High Court, going to the magistracy, about all those so-called personal, family, and commercial disputes that form the anchorage for ground 2. And when you read the judgments and rulings and orders we have placed in document number 11 all the way to 19, the common denominator is that the courts have ruled all those disputes in favor of the Honorable Linturi. So the $1 million question, Honorable Chair, yes, let's assume a motion like this can be based on personal court disputes. Does it mean if someone loses court cases, they have lost at the Court of Appeal, which is the highest court on those matters, they can't go to the Supreme Court? They have lost at the High Court. They have lost at the Employment and at the Environment and Land Court. They have lost before all the magistrates of this republic, sitting in different court stations. How can it then material that the courts have ruled in favor of the Honorable Linturi form the basis for ground 2 of the allegation before you? You have been told because, again under ground 2, because of those family cases, the Honorable Linturi is facing an imminent arrest, imminent prosecution, and whatever. We have already placed before you a letter from DCI, of course flowing from the countless victories the courts have given Honorable Linturi, in which the DCI says they have investigated those matters and they have forwarded the file to the DPP. The DPP has reviewed all those files and advised, quote unquote, they be closed with no further police action. So it is up to you. Who do you believe? Is it the DCI who has written, confirming, and they didn't write yesterday? It was way back last year, more than a year ago. Who do you believe? We will be submitting before you, Honorable Chair, that this mover of this motion is a proxy, and specifically a proxy of the Honorable Member for...
Chair, kindly, there are some words that we shouldn't allow. Let me just explain what describe somebody. Honorable Omanyo.
Say your point of order. I think we should use a language that is acceptable and not describe anyone in a manner that degrades them.
So that we don't waste time, I'm happy to withdraw the word proxy, Chair. I would also suggest when the interjection my clock be stopped because they eat on the time. So I will rephrase, Honorable Chair, and say that the real mover of this motion before you is the Honorable Member for Aldai. We shall play before you when we get there video evidence, specifically video number 4, that confirms that. We shall invite you to look at all the cases that form the basis of ground number 2, of allegation number 2. They are all cases between the Honorable Linturi and the Honorable Member for Aldai. We will be asking you to look at page 252 on document number 10 of our battle, which will confirm to you that this allegation is actually a lie. And it confirms the DCI, the ODPP, closed all these matters with a formal recommendation for no further police action on the 31st of May last year. And then, of course, we'll be asking you, Honorable Chair, when we get there, all these so-called family, criminal, civil, and family and commercial disputes, they were matters that the House considered when it approved the Honorable Linturi. Is this motion seeking to reopen a decision already the House made, to the extent that it has that ground 2 of the motion? Is it seeking to reopen a matter the House considered, cases it considered, allegations it considered and nonetheless approved. And when we get there, we'll be humbly suggesting to you, it is not possible. A cabinet secretary cannot be removed from office on account of matters that the House already considered in making the decision to approve their appointment. And while on that matter, Honorable Chair will also be telling you, all those family law disputes anyway revolve around acts and omissions that took place or allegedly took place before the appointment of the Honorable Linturi as a cabinet secretary. So again, the question will be asking you, does Article 152 of our Constitution provide for removal for conduct while in office, or does it provide for removal for conduct prior to assuming office? And of course, when we get there, our submission will be for matters that allegedly happened before appointment. Those are matters that belong to the committee that vetted the Honorable Linturi. And on the record, because there is a house of record, it should be clear from your answer that those matters were indeed, as a matter of fact, considered by the House. Allegation 3, Honorable Chair and members, is the one we found quite interesting. It claims the Honorable Linturi should be removed from office for two things. Well, they still mention the personal life issues, but two additional things. They say one of them is the Honorable Linturi was involved in a spat with journalists. And because he was involved in a spat with journalists, the president should dismiss him by resolution of the House. Number two, it says, the Honorable Linturi stormed some factory and ordered its closure. What is interesting about this allegation is the evidence given in support of it. It is a letter supposedly authored by Senior Counsel Ahmed Nasir Abdullahi and a press statement. I repeat, Honorable Chair, a press statement. That's the evidence. Not by the journalist supposedly assaulted by the Honorable Linturi, but by the President of the Law Society of Kenya, who is not a journalist, who does not claim to have been present at the time when the so-called spat occurred, and will be trying to tell you it is all hearsay on the back of hearsay. And when we get there, we'll be, of course, telling you why hearsay cannot justify the making of allegations such as the ones before you. When we get there, Honorable Chair, we'll be asking you, can a resolution under Article 152 be approved on account of acts and omissions of third parties? In this case, the acts and omissions of the government bureaucrats at the NCPB. Or must there be an excess, as we were told by the Supreme Court? We have attached, we will urge you when we get there to look.
Order by Honorable Manyo.
The Council for CSME, Linturi, has mentioned quite in an extensive way about ex-wives and all that. I think if he must play the video, if that ex-wife is alive and can be here, it will be in order, because sometimes talking about people who can also talk for themselves is fair.
We'll get there, Honorable Chair.
Permit me to say something.
Council, you can proceed.
The ex-wife is very much alive. You may be, I do contact ladies, I do talk to ladies in the evening. I talked to her last night. She's very much alive. After reading the response that had been filed in the court, I said to her that, look, I understand you had one child with the Honorable Linturi. She said, no, I mean, I never had a child with that person.
Senior Counsel, you did your part, but you have given us a good break of laughter.
Is that the way all this is eating into my time out, that will be calibrated accordingly. But Chair, I was about to tell you that the person I have come to represent here is a man who has held many state offices in which he has served with honor and distinction. We have particularized that in paragraph 2 of our affidavit. The man I represent, contrary now to the calumny writ large in our press and other fora, has actually had very impressive performance as a cabinet secretary, recognized not by himself, not by his ministry, but indeed by independent agencies of state that are not under his control and direction. And to that extent, when we get there, we will show you a document, I believe number 4 in our response, from the Central Bank of Kenya. And I think even the haters of Linturi will agree, Honorable Chair, that the Central Bank of Kenya is one of our most credible public institutions. So if such an institution tells you Linturi has achieved phenomenal success as a cabinet secretary for agriculture, it must count for something. You may not need to buy it entirely, but it must surely count for something. The man I've come to represent here, Honorable Chair, unfortunately, has been the victim between 2018 and 2022 for a 5-year period of a state-sponsored public shaming, public vilification, public defamation campaign. We are mentioning this, Chair, because as human beings there is a tendency sometimes to say it is that bad guy again. The Honorable Linturi, of course, as you'll find in his response about this issue, is that this campaign was sponsored by the previous administration, which again latched onto the personal, commercial, family disputes. So that at every TV broadcast for those 5 years, at every possible newspaper headline, at every possible FM radio show, it was always Linturi the bad guy. And specifically, I represent a man who has been painted to the world as an incorrigible womanizer, criminal, fraudster, thug, scoundrel. You can call it whatever. I represent a man who, unfortunately, for lack of a better word, Honorable Chair, is the dog that has been given a bad name. But we must tell the move of this motion, we don't dismiss people from state office because they have a bad reputation, especially when that reputation is an artificial creation of a previous administration that was only doing this to punish the Honorable Linturi for supporting the candidature of the Honorable William Ruto as President of the Republic of Kenya, as opposed to the other candidature that the administration then in place preferred. What I'm trying to tell you, Honorable Chair.
May I say something? May I raise an objection?
Right, I'll allow.
Senior Counsel, just a minute. Honorable Kajwa.
No, on account of his age, he can go first.
Senior Counsel.
May I? We must move from this culture, which was started in Kanu days, of keeping on mentioning the head of state in proceedings in order to get sympathy, appreciation, and respect. His Excellency William Ruto is not a party to these proceedings. We should not mention his name at all, so that to impress anybody. Let us move from this culture of moving of mentioning head of state. You don't get such a thing in England. where people are mentioning the Queen in the proceedings or the Prime Minister in the proceedings and so on. Nobody has done anything against Linturi because he was not friendly to the previous regime headed by His Excellency Uhuru Kenyatta, or because he is close to His Excellency William Ruto. Let us keep out mentioning names of heads of states.
You Senior Counsel, Honorable Bajon.
I think we need to be relevant. Even in open submissions, you must be relevant to the facts in issue. Those facts are fake fertilizer, and the ones you call love and affliction or whatever they are. To get into politics will be getting out of the rail, and many of these members know how to play politics than people on your side. So just come back to what is relevant and prosecute your case and finish it.
Honorable Chair, I'm guided, Honorable Chair, just for the record, I'm not saying this because it is irrelevant. Every legal dispute has a context in which it arises. And if you just allow me to finish, it will be clear why I'm mentioning this. And specifically so that we don't waste more time. All I'm trying to say, Honorable Chair, is that it is humanly possible for us to fall into the trick of saying it is that notorious Linturi. If there are serious allegations about him, they are made because they are true. And that's the only danger that I'm warning the committee about. That is the only context in which I tell you, because it is public knowledge, that the man I represent was a victim of that public shaming, public vilification campaign on TV, on whatever. I am here to humbly tell you, Honorable Chair,
I'm afraid the member has no power to warn the committee. Yeah, that's what he said. I'm warning this committee. It is not within its power.
It's a legal term, Chair. I think my colleague, when we say warning, it's not in the ordinary sense of the word. It is in the sense used to direct juries about the dangers of prejudice and the dangers of bias. So it is not a warning, of course. Honorable Linturi has no capacity to warn anyone.
Thank you, Council.
It's a term of art and it's a legal term. I think my colleague doesn't know.
Thank you. You have educated those who are not learned fellows, and we have.
I'll say something. Let us not forget. With a serious tone. Let us not forget. He has told this select committee that he is under surveillance. So when he uses the word warn, he knows what he's talking about.
Thank you. The honorable members are hearing, and we have
Honorable Chair, with all the interjections now, I don't know how much of my time has been spent in this.
Don't worry, we will take care of that.
Okay.
We will take care of that.
Okay.
And, we have taken note of what you have said. Thank you.
Much obliged. So, Chair, I was saying that when you sit as a judge, because this committee is sitting as judges, the practice in the legal world, and likely there are many legal minds in your committee, is always to one of the dangers of putting in your mind, oh, he's that bad guy. And because he's that bad guy, he must be guilty. The allegations must be true. That's all I'm doing by giving you that context. And I must also tell you, Honorable Chair, we must be dangers of the crucify him approach to a matter like the one before you. In the Christian Gospels we were told, because the mobs were baying for blood, crucify him, crucify him. He's a bad guy, therefore and I'm saying again, it is easy for you to be told cries of farmers, cries of victims. And of course, we are not here to trivialize. Farmers have suffered in this matter. No one can deny that with a straight face. What happened is as unfortunate as it can get. But that would not justify a lynching or a crucify him approach to the matter before you. That is why under the Constitution, Chair, you are to investigate. Your duty is not just to roll heads, to serve somebody's head in a platter so that the masses can stop saying crucify him. We are baying for blood. Honorable Chair.
Let us be honest. Let us not waste the time of the committee. We are doing so, I'm sorry. Linturi himself has said very loudly that the farmers who received these fake fertilizers should be compensated. He has said so very loudly.
Honorable Chair, I will seek your protection because I now believe there is a strategy to interject so that my thoughts don't flow. I never talked when they were talking for a whole 40 minutes. There are many things they said that I had issues with.
Council, we are aware of all this, and Senior Council, you had your time, and if we keep interjecting, then we will interfere with his time. We have already, we will add him some more time as a result of what we are doing. Kindly be patient because you had 40 minutes to...
I agree. Thank you very much. But only one sentence.
Yes.
He did not interject because we are talking sense.
Honorable Moses.
Chair, I think we want to urge Senior Counsel Haminwa and my brother here to give him time to finish, because when they are also raising their issues, we kept quiet. Because I remember at one point, the mover talked of a fake minister, and we didn't raise anything. So let us allow him to proceed the way we allowed also.
We have already said that. Please let us not interject.
The member is supposed to be neutral, so he's saying we didn't. I thought they are supposed to be the ones to say we. He is supposed to be a neutral arbiter in this thing, unless he declares.
We are a neutral team.
Chair,
yes.
He said we parliamentary language. We didn't interject.
He is referring to us as parliamentary committee, and we meant all of us. So please let us not do a lot of interjection, because that will consume a lot of his time and also interfere with the flow of his presentation. Thank you. You can resume.
Thank you, Honorable Chair. And I was saying it is because of these dangers of bias, prejudice, that our law forbids the use of character evidence, disposition evidence, similar fact evidence. Basically, all I'm saying is that this matter is not one in which we can judge Linturi for his so-called reputation. I now come to the mandate of this committee, Honorable Chair, as directed by the Speaker. The Speaker said these proceedings are quasi-judicial and they have to be characterized by heightened degrees of conscientiousness, fairness, transparency, and whatnot. My understanding, Chair, of which I could be wrong, is that this committee is sitting as judges. You're not sitting in this committee in your capacity as members of the...
We will make our judgment.
Point of order, Chair. I think let's go back to the basics, that for the opening remarks, somebody should not be interrupted. I think that is the basics of any proceeding.
That's what I'm trying to say.
It's unfortunate we allowed it, but I think, Chair, you need to assert that for opening remarks, there are no interruptions whatsoever, period.
And I wonder why we are getting emotional. Please let us be patient, let us listen, let us not jump and make conclusions. And we were very fair with Honorable Wamboka and his team. So I don't see why we should, always interject when the council is presenting. Please let us be patient and give him the remaining time, please.
Thank you, Chair. I was to say you sit in this committee as judges, and the only point I wanted to highlight in this, of all the things human beings do, Honorable Chair, of all the offices human beings occupy, it is only in the office of judge that a human being takes the position of God to to pass judgment on another human being. The other things we do are temporal. The administration of justice is something divine because it elevates the human being making that decision to the level of God. That is why our constitution in the third schedule, Honorable Chair, says justice is to be administered, quote unquote, without any fear, favor, affection, bias, ill will, prejudice, or any political, religious, or other influence. I'm humbly submitting to you that this is the applicable constitutional threshold. That oath of office for judges is the applicable constitutional threshold